So let's dive into a story that's a real classic David versus Goliath tale. We've got a single homeowner squaring off against the powerful board that runs his entire community, his homeowners association. But this isn't a fight with sticks and stones. Oh no. This is a battle fought with bylaws, meeting minutes, and one man's relentless demand for simple transparency.
You know, if you've ever lived in a place with an HOA, you probably know the feeling. That sense that you're just along for the ride, and they're making all the rules. But what happens when you get that nagging suspicion that the people enforcing the rules aren't actually following them themselves? Well, this is a story about what it takes to stand up and demand some accountability.
And this is our guy, William Kayser. He didn't just grumble to his neighbors or write angry posts online. Nope, he took his fight to a formal hearing at Arizona's Office of Administrative Hearings. He actually filed a petition against the Barclay Place Homeowners Association, turning what could have been a neighborhood squabble into a full-blown legal case.
So what was his beef exactly? Well, it wasn't just one little thing. It was a whole pattern of problems that he saw. Let's break down the main complaints that Mr. Kayser laid out for the judge.
And listen, these were serious accusations. First, Mr. Kayser claimed the HOA completely failed to get a proper annual audit done by an outside company, which, by the way, was required by their own rules. He also said they stonewalled him over and over when he asked to see official records. And maybe the biggest one, he accused them of not giving proper notice for a really important meeting, the one where they jacked up the annual dues. These were the pillars of his entire case.
Okay, so this is where it gets really juicy. When they finally get into the hearing room, the stories just completely clash. For every single one of Mr. Kayser's claims, the HOA had an answer. It really turns into a classic he said, they said situation.
First up, the money. Mr. Kayser points straight to the bylaws. Right there in black and white, they need an annual audit by an outside firm. The HOA's management company basically said, hey, our CPA looks at the books every month, that's good enough. But then, and you gotta love this, their own witness couldn't seem to decide if their CPA was actually an outside party or an in-house guy. Whoops. All right, next up, transparency, or the lack of it. Mr. Kayser shows he made a bunch of documented requests for records and got nothing. The HOA's response is, wow. They basically admitted they didn't hand over the documents and then blamed it on a former board president who apparently packed everything into boxes and they just couldn't find them all? I mean, come on. Not exactly a vote of confidence in their record-keeping, right?
And that brings us to the mysterious case of the phantom meeting, the very one where dues were increased. Kayser says he saw a notice for it, but on the day of the meeting, the notice was gone. So he goes to the location, a furniture store of all places, and crickets. Nothing's happening. The HOA swears the meeting happened and that they just taped a notice to the mailboxes like they always do. So, who's telling the truth here?
So you've got two completely different versions of reality. In a situation like this, what does a judge do? They have to sift through all the evidence, listen to the testimony, and figure out which story is more likely to be true. It's all about the preponderance of the evidence. So how did the judge land on this one?
All right, let's get to the decision. The administrative law judge, Kowal, went through every single one of Mr. Kayser's complaints and delivered his verdict. And the result? Well, it wasn't a simple win or lose. It was a lot more complicated than that.
And this little scorecard really breaks it down perfectly. Let's look at the scoreboard. The annual audit, the judge said the HOA absolutely violated its own bylaws. That's a big win for Kayser. What about providing records? Yep, the HOA failed. Another point for Kayser. The meeting notice, the judge found their method of just taping it to mailboxes was improper for that kind of meeting. That's 3 wins for Kayser. But on the actual dues increase, the judge ruled the board had the authority to do it. So a win for the HOA on that one.
Now, if you were just counting up all the little technical points in the original petition, Mr. Kayser actually lost on more items than he won. So if you're just playing a numbers game, you might think he lost the case. But that is not how the law or this judge saw things, not even close.
This is the absolute key, right here, in the judge's own words. He wrote that Mr. Kayser prevailed on the most substantial issues. See, it wasn't about the quantity of wins, it was about the quality. Think about it. Financial oversight, access to records, proper governance, these are the big ones. The judge decided those wins outweighed everything else, and that officially made Mr. Kayser the prevailing party.
So what does it actually mean to be the prevailing party? Well, it comes with some very real consequences. The judge didn't just say, you win. He issued a final order, a list of things the HOA had to do. And this is where we get the real lessons from this whole saga.
First and foremost, it means money. $2,000. Because Mr. Kayser was the official winner on the most important issues, the judge ordered the HOA to pay him back for his entire filing fee. That sends a pretty powerful message, right? Holding your HOA accountable shouldn't bankrupt you when you've got a legitimate case.
So the final order laid it all out. Number 1, the HOA was commanded to start following its own rules and the state laws. Imagine that. Number 2, they had to finally give Mr. Kayser all the documents he'd been asking for. And number 3, they had 40 days to cut him that $2,000 check. These were real, concrete actions they were forced to take.
So what can you, as a homeowner, take away from this? 3 huge lessons. First, know your bylaws. They are the rule book. Mr. Kayser won because he knew exactly what the rules said. Second, document everything. His paper trail was undeniable proof. And third, maybe the most important, the process can actually work. It might be a grind, but a single, determined person with facts on their side really can hold a powerful organization accountable.
And that kind of leaves us with one last thought, doesn't it? This entire case, this whole fight, it all started because one guy was just paying attention. So the next time you see a notice taped to your mailbox, or you get an email about a fee increase, it's worth asking yourself, do you really know if your HOA is playing by its own rules?